So with that, I will turn to Gene Healy.
Thank you, Nancy. As Nancy mentioned, I've just completed my first book. It's called The Cult of the Presidency, but I sometimes like to call it The Futility of Hope. It's not really a sunny and optimistic book, but what it is about is how the expectations and the aspirations that the American people invest in the office virtually guarantee an unhealthy concentration of executive power. David mentioned earlier that we're interviewing, use the term interview, we're interviewing these candidates to hold this office of vast powers. And when you listen to the candidates talk, you sometimes have to wonder what job it is they think they're running for. Hillary Clinton said a couple weeks ago at a speech at the University of Pennsylvania, she says the president needs to be ready on day one to be commander-in-chief of the U.S. economy, which is an interesting concept. I haven't seen it in the Constitution. John McCain holds up Teddy Roosevelt as one of his favorite presidents. Not a big fan of Teddy Roosevelt. I think he was one of the more ridiculous and obnoxious figures ever to occupy the Oval Office. But McCain says he was a great president because he liberally interpreted the constitutional powers of the office and, quote, nourished the soul of a great nation, as if soul nourishing is part of the president's job. Amazingly enough, in the start of his late and unlamented presidential campaign, Mike Huckabee, when he announced his candidacy on Meet the Press, Tim Russert asked him why he was running, and Huckabee said, in terms sort of like McCain's, that, well, Tim, we need positive, optimistic leadership to turn this country around and see a revival of our national soul. A revival of our national soul. And you have to remember at this juncture, Mike Huckabee is basically a guy who's famous because he used to be really fat. And he's going to save the national soul, which makes you wonder, what kind of shape is the national soul in? But I want, in keeping with the focus of the panel, I wanted to stay pretty close to, I'm actually going to cover a lot of the same ground that David covered so nicely. So John Yoo is going to have a rough morning this morning. But I'm going to start by doing something I don't normally do, which is to say something nice about George W. Bush and his administration. If nothing else, it had pedagogical value because, well, when I graduated from law school, which was in 1999, in your typical con law textbook, mine was about, I think, 900 pages. Your typical con law textbook, the 900-page book has about 80, 70 pages on executive power. It just wasn't, you know, as compared to 500 pages on due process and the 14th Amendment, executive power was not as big an issue. I mean, I certainly agree there have been the imperial presidency is a problem that's been with us for a long time. George W. Bush didn't invent it, but the last few years have crystallized some things, and I suspect that people are busily re-editing and recompiling constitutional law textbooks as we speak. There's new interest in constitutional limits on executive power because of the staggering theories of executive power that the administration has advanced. And the core of that theory is to take a line from the most recently revealed torture memo, is that, quote, Congress can no more interfere with the president's conduct of the interrogation of enemy combatants than it can dictate strategic or tactical decisions on the battlefield. Now, if you take out interrogation of enemy combatants and just replace it with any other measure that Congress might want to regulate, whether it's wiretapping, imprisonment without trial, and that is the basic theory. America is a battlefield. On the battlefield, there's one commander-in-chief, And it makes as much sense to tell the president he needs to get a warrant to tap a phone in New Jersey as it does to, order him to take a particular hill or not to use artillery in a certain engagement. How far does that theory go? Well, John Yoo has written unironically of quote, the president's right to start wars. Using this theory, of course, we know about the so-called terrorist surveillance program and the way in which the administration has bypassed the statutory framework set up by Congress for foreign intelligence surveillance. And that publicly what they've said is that this has only been done with regard to international calls where one party is outside of the United States. But in April of 2006, Attorney General Gonzalez testified before Congress, and he was asked whether this theory of executive power would allow domestic wiretapping, phone calls between two Americans in the United States or emails between two Americans in the United States. And Gonzalez said, I'm not going to rule it out. Later that day, the Justice Department spokesperson issued what you might call a non-denial denial of the Attorney General's remarks. And that the statement was worded as follows. The Attorney General's comments should not be interpreted to suggest the existence or non-existence of a domestic program or whether any such program would be lawful under the existing legal analysis. So thanks for that. That clears that up. And of course, there's the Padilla case, really, I think, frightening claim that the president has the power to designate an American citizen picked up on American soil an enemy combatant and hold that citizen without due process for the duration of the war on terror. That is about the most frightening power you can imagine an executive having.